Today we're in a Texas courtroom where 45-year-old Allejo Agiri is facing a state jail felony theft charge. We're talking stolen metal, pallets, and a truck bed full of scrap that allegedly turned into just trying to make some money. You know how it is. The judge is about to walk him through deferred adjudication, basically a second chance that keeps a conviction off his record if he plays by the rules. But watch closely. This isn't just about theft. You'll see a judge drill into his job situation, call out the way he relies on his parents, and then hit him with a surprise drug test that completely flips the mood in the room. Is this a man who made one mistake, or someone hiding much more than he's willing to admit? Stay with me, because by the end of this hearing, his own words and that UA result tell a very different story than the one he started with.
Court is calling 2023 CR 2080B, State of Texas versus Allejo Agiri. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Jesse Sepulveda for Allejo Agiri.
All right. And are you Mr. Agiri?
Yes, Your Honor.
Counsel, have you received all the discovery that you reviewed with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Agiri, no application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, you proceeding on the indictment as presented?
Oh, we are, Your Honor.
All right. Mr. Agiri, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney?
Yes,
Did
Your
you understand it? Did you sign it in all the appropriate places?
Honor. Yes,
Did you understand you're charged with the offense of theft $2,500 to $30,000 as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
So let's pause here and break down exactly what's on the line. Mr. Agiri just confirmed he understands he's charged with theft of $2,500 to $30,000. That's a state jail felony in Texas. That means the judge could legally sentence him to anywhere from 180 days up to 2 years in a state jail facility and fine him up to $10,000. Instead, the court is moving toward deferred adjudication, which is huge. In simple terms, the judge is saying, I have enough evidence to find you guilty, but I'm going to hold off and put you on a strict form of probation. If he completes that probation successfully, there's no final conviction on his record. If he messes up, the judge can come back, formally find him guilty, and sentence him within that full punishment range. What do you think? Is deferred adjudication a fair second chance here? Or is the court being too generous given the police report we're about to hear?
All right. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt and apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, Judge, we're just asking you if you would grant my client his allegation for deferred. I believe he's got no priors. He's learned a valuable lesson and believe he'll be back here.
All right. What lesson have you learned?
Make sure it's that I make sure it changes before I attend to help anybody else. Make sure I know all of the everything's all the ongoing that are happening.
No, I mean, that's not what the police report says. I read the police report, and the police report says that three subjects were loading wooden pallets. The subjects were identified, you and this Canales person and some unknown third suspect that fled the scene on foot. Jay Smith confirmed by he happened to be arriving on the property when he observed the subjects loading wooden pallets on the bed of the listed truck. When he confronted them, after being confronted, the subjects put back the wooden pallets, but large metal materials were found on the bed of the truck. Jay Smith stated, Agiri told him, I'm just trying to make some money. You know how it is. I then observed the bed of the listed truck that contained an electric motor, metal bracket, and 4 metal poles, miscellaneous metal scraps, and a long angle iron. So, are you employed?
Notice what just happened. When the judge asked him what lesson he learned, his answer was vague, emotional, and honestly a bit confusing, something about helping others and knowing everything ongoing. But then the judge pulls out the actual police report, and the tone shifts instantly. According to that report, there were 3 people loading wooden pallets and metal into a truck, and when they were confronted, they put some pallets back, but the metal was still there. And then there's that damaging line. "I'm just trying to make some money. You know how it is." That doesn't sound like a guy accidentally in the wrong place. That sounds like someone knowingly hustling scrap to make cash. Remember, by pleading to this charge and accepting deferred adjudication, he's essentially accepting the state's version of events. So here's the question for you. Do you think his lesson learned answer was sincere, or was he trying to soften what's written in black and white in that report?
Wait,
Yes, Your Honor.
doing what?
I'm a caregiver. Right. Oh, sorry. Sorry.
What do you do?
Caregiver, massage therapist.
Massage therapist.
That's correct, Your Honor.
So how do you go from massage therapist?
Your Honor, COVID, so everything kind of came to a halt.
No, you're telling me you're currently a massage therapist.
I am a licensed massage therapist, but ever since COVID hit, it went to almost zero.
And where were you a licensed massage
In
therapist?
Arizona.
I can't hear you.
In Arizona. I've been here for 2 years.
All right, could you please stop rattling the paper because the court reporter can't hear? All right, so you're in Arizona, you're a licensed massage therapist, and then you come to Texas?
That's correct.
So what do you do for a living here in Texas? That's what I'm asking you about.
I'm taking care of my parents. They're disabled.
So you don't have a job.
It's considered a job, Your Honor.
Are you getting paid for the government by that?
No, Your Honor.
Then how are you making your money?
My parents, they pay me.
All right, that's going to stop. You get it. Will you please stop rattling it? Counsel, would you take the paper for him? I'm sure he may be a little bit nervous.
No, I'm not nervous. I'm just.
Well, stop rattling the paper then. So you're getting a job. How old are you?
45.
Yes, you're not going to be living off your parents. You're getting a job.
I'm not living off of my parents. Your
Are they paying you?
It's very little, Your Honor. I'm not living off of my parents, Your Honor.
Where are you staying? Who do you live with?
I have a roommate.
So how are you paying for where you live?
Scrapping, doing side jobs, landscaping.
This part is awkward and important. The judge is not just sentencing a thief. She's evaluating his entire lifestyle. He says he's a licensed massage therapist from Arizona, but in Texas, he's mainly taking care of his parents, not getting paid by the government, living with a roommate, and making money from scrapping and side jobs. Then he admits he gets some money from his parents, even if he insists it's very little. For the judge, that's a red flag. At 45 years old, on a theft case that literally involves scrap metal, telling the court you survive off your parents while scrapping on the side looks really bad. That's why she keeps hammering the word job and pushing him towards stable, full-time employment with a paycheck. Viewers, what do you think? Is the judge being too harsh by calling him out like this? Or is she right that relying on parents while doing risky side hustles is exactly how someone ends up back in front of her?
Mm-hmm. You're getting a real job. I'm not going to allow you to take money from your parents. That's not going to happen. You're 45 years old. If you're helping out guess what? If you're helping out your parents, then you don't take money from them.
I'm not, okay.
You just told me you received, did I not hear that right? Didn't he just counsel? Did he say he received money from his parents for taking care of them?
It's a very small amount, Your Honor.
All right. So you're not getting money from your parents anymore. I don't know. You're 45 years old. You need to support yourself. If you're helping, no, what's ridiculous is that you're 45 years old. You say that you're helping your parents, and actually your parents are paying you to take care of them. They shouldn't be giving you money. If you are helping your parents, you shouldn't be accepting money for them.
Your Honor, you asked me a question and you caught me off guard, so that was the answer that I gave you, Your Honor.
What, is it not true?
But no, because I feel like you're belittling.
No, is it not true? Is it not true that you're accepting money for them?
No, it's not.
So you don't accept any money from your parents?
Your Honor, what it is, I mean, literally less than $50. I mean, literally. I gave you that answer, but I wasn't expecting to be asked that question, Your Honor. Yeah, but you're belittling me in front of this court. That you don't know me.
I know that you're 45 years old and
Correct,
that you
Your Honor.
say you're taking care of your parents.
Correct.
I
Your
know
Honor.
that you just pled to a theft case, so you were stealing. I know that you are getting money from your parents. You're going to get a job. So
I have
in this court,
Okay, yes, Your Honor.
you're not doing scrap meddling.
Yes, Your Honor.
You're getting a job with a paycheck. Do you understand?
Yes, Your Honor.
And if you want to be disrespectful to the court, I can, and I'm sure your attorney told you that if need be, so that you can have an attitude readjustment, I can do as a condition of your probation, 180 days at the state jail facility, so you can see how the state jail facility is for a little bit. I don't know why people don't want to get jobs. That's how you support yourself. You're 45 years old. You're not a teenager. I have teenagers who come to court and they don't have jobs, and I require that they get jobs. So you're going to get a full-time job. So it's a $500 fine, probated, 2 years deferred adjudication, proof of employment within 15 days, and it's going to be full-time employment. So that means 40 hours a week. If you need to get 2 part-time jobs to make 40 hours, then you get 2 part-time.
Here's the deal the judge finally puts on the table, and it's more structured than it might sound at first. On paper, it's a $500 fine, 2 years of deferred adjudication, and no immediate jail time. That sounds lenient, but listen to the conditions. He has to show proof of full-time employment, 40 hours a week, even if that means juggling 2 part-time jobs. He's barred from working in home health care or with minors, likely because of the trust issues tied to a theft conviction. He owes 120 hours of community service, has to pay restitution, attend anti-theft programs like CATS 1 and 2, and he's ordered to submit to a drug test today. This is classic second chance with a short leash sentencing. The judge is trying to push him into stability, a job, structure, treatment if needed, but she's also setting up guardrails so if he lies, uses drugs, or doesn't work, the court has plenty of leverage to come down hard. Would you take this deal if you were in his shoes?
Time jobs. There's to be no employment as a home health care provider or with minors. Do you have any children? Do you have any children?
Your Honor, I have one child.
What are their ages?
He's 22.
All right, 120 hours of community service restitution, CATS 1 and 2. And CATS 1 and 2, my understanding, that's a program to tell people not to steal. Take in consideration JN number 2112854. I'm going to want a drug test today. If it's positive, is it going to be negative?
No, Your Honor.
All right, if it's positive, I'm going to want intensive outpatient treatment with probation and a TAP evaluation. If negative, I'm going to want regular UAs. I'm going to want field visits 1 time per month until further notice. Probation, is there anything else he needs? Yes, here. Is there anything else you need from the court to be successful?
No, Your Honor.
Sure. All right, good luck to you. Probation will go over conditions with you, and you'll need a UA sample today.
Yes, Your Honor.
Thank you. Did probation give you the results of his UA?
Yes.
So probation, what is he all positive for? He told me he would be negative.
Yes, Judge. So,
No, it's not.
Cielo Jimmy Hernandez did the UA here in court, and the results were positive for methamphetamine, opiates, and marijuana.
Here's the twist. The whole hearing was building toward. Remember earlier when the judge said she wanted a drug test and asked if it would be negative? He told her no when asked if it would be positive, essentially promising he was clean. Now we find out the UA is positive for 3 substances: marijuana, methamphetamine, and opiates. Even if he tries to explain away the marijuana and deny the meth and opiates, the damage is already done. In the courtroom, this isn't just about drug use. It's about credibility. Judges rely on defendants' honesty to decide whether probation is safe, whether treatment might help, and whether they can trust what's being said at the podium. By not telling his lawyer about his recent use, he also blindsided his own defense. The judge even points out that his attorney had to come back because of this surprise. This is a perfect example of how one bad UA and one dishonest answer can turn a clean deferred adjudication into a much more serious situation. Be honest. If you were the judge, would you still trust his word after this?
Marijuana.
All right. So what's going on with you?
All I can tell you, Your Honor, first of all, I apologize. I didn't mean anything intentional earlier. You just caught me off guard with the questions. The only thing I can tell you in regards to that, the test. I do use marijuana. And
All right. So we got the marijuana out of the way, but here's the
the
thing.
whole medicine that I have, that's the only thing I can say. Yes, ma'am. Yes, ma'am.
I specifically asked you if you're going to be positive for any drugs, if there are any drug issues.
Correct.
Your response to me is that you were going to be clean. So let's start with the marijuana.
Yes,
So
ma'am.
that's a positive for marijuana. So you were a bit dishonest with me about that. Why?
Only because it's been like 2 or 3 weeks, and I thought maybe that it wouldn't come up. That's all. That was my sincere answer.
So now we have the meth issue.
Your Honor, I don't know. I don't do it. I've never. If you look at my whatever history, I've never had any drug charges. I've never had any theft charges. I've never been convicted of anything. I've never been on probation.
What does that have to do with you telling the court that you would be negative and that you didn't use drugs? And now we're discovering that you
Yes,
do use
yes,
drugs.
Yes, ma'am. As I mentioned, I thought that it's been like 3 weeks since I used marijuana.
So you thought
But it was
that,
very potent. So it obviously still came up. I thought that it wouldn't come up.
all right. So you were dishonest with the court. So about the marijuana. So why should I be trusting you about meth and opioids?
Yeah, I mean, as well, I'm with my parents every day. I'm with my daughter every day. I have no time for that. I mean,
How's your daughter?
she's 22 years old.
Mhm.
She just moved here from Tucson to come and be with myself and my parents. So I don't have time for that. I don't have the money for it. I don't have, aside from that,
Are you paying for your marijuana?
I mean, yes, but even that has become very minimal.
Well, no, I mean, here you are, a person who is not employed, actually, because you're just doing odd jobs. Doing odd jobs is not real steady employment.
Yes,
You're receiving funds from your family and you're doing drugs. And I know for a fact,
Yes, ma'am, that's how it looks.
and I know for a fact
Yes, ma'am.
that you didn't tell your attorney any of this.
It wasn't brought up because there was no reason for it to be brought up. I didn't have any drug charges or possession of any drugs or of any sort.
So you didn't think it was important for your attorney to know that you may test positive for drugs, even after I said you're going to do a UA today. You would have thought you would have turned to your attorney and said, hey, I may end up being positive. Let me just tell you something. I've been a defense attorney before, and I would tell all my clients, please be honest with me, because this courtroom is a minefield, and I'm trying to get you to make the best decisions possible. And when you're not open and honest with your attorney, guess what? Your attorney's standing up here, and I don't hold it against your attorney because I know you didn't tell him. Your attorney's standing up here telling the court information based upon what you're saying, going on you that it's true and it's not.
Yes, ma'am.
So now guess what? Your attorney's Tuesday has turned into a Monday. You know why? Because he came here and thought he had finished with this case. And then we have to call him back because you're testing positive.
Yes. Yes.
Aren't you ready to go to lunch, Mr. Svoboda?
Yes, Your Honor.
So this is what we're going to do. The TAP evaluation, we're going to follow the recommendations of the TAP evaluation. However, if that TAP evaluation says outpatient treatment, I want to start with intensive outpatient treatment. And if it says inpatient treatment, then you're going inpatient. Because what's concerning to me, of course, is the marijuana and the fact that you were dishonest. But also what's concerning to me is the meth and the opioids. That I find that very concerning. And I know people think that marijuana is okay, but in this court, you're on probation. You're not allowed to drink alcohol and you can't do marijuana because marijuana is not legal in Texas.
Yes, sir.
There are only a few exceptions.
I did tell him.
Your Honor, you wouldn't allow him to do regular UAs as part of his probation. I mean, I know.
Oh, can I ask what is you tasked about? Or what?
Oh, they're going to do a TAP evaluation and see what the TAP evaluation says.
I'm just not familiar with that, Your Honor. What is?
Oh, it's sort of like a resume for your drug history.
Oh, okay.
Yeah.
I mean, like, okay, that's fine, Your Honor. Yes.
All right. And when people are dishonest to me about their drug use, that basically tells me where they are as far as their sobriety is concerned. That's the reason why I asked that question, so that I can figure out where you are as far as your sobriety is concerned. And I will tell you, I've only had probably approximately 2 to 3 people who were 100% honest with me with their drug use. And guess what ended up happening to those people? Thank you for your honesty. We're going to start with some intensive outpatient treatment. And if you need anything else, come back to court. Because the whole reason for you being on probation is I'm hoping that everyone who's placed on probation is successful. You understand?
Yes, sir.
All right. Thank you, Mr. Sepulveda, for running over here.
Thank
You
you.
ran over here quicker than Texas Longhorns running back.
I'm gonna see that.
All right. We're going to see what happens with LSU this year.
Judge, is there anything that you want in regards to UAs until?
Yes. I want him to be tested for levels. And if those levels increase, then I'm going to want a supplement filed for the court to review, and then a motion to revoke may be filed. You understand? So when you leave this court today, you had better not do any marijuana or any of that, you know?
Yes, sir.
All right. And make sure he's tested at least once a week, and give him the job rehab so we can make sure that he's employed and has a job. All right. Be honest next time.
Actually, I did. Okay, yes, sir.
Yeah, all right. Thanks.
The last one about the job.
Make sure that he is given workforce or something so he can get employed.
I have some emails that we've gotten recently, so I'll print them out for him and give that to him.
All right. Thank you. You're going to feel so much better when you have a stable job. Okay.
Yes, sir.
All right. Thank you.
So let's zoom out and wrap this up. Allejo Agiri walked into this Texas courtroom on a state jail felony theft charge involving pallets and scrap metal, facing up to 2 years behind bars. Instead of sending him straight to a state jail facility, the judge gave him deferred adjudication, a structured second chance that could keep a conviction off his record if he follows the rules. But that chance came with serious strings: full-time employment, restrictions on where he can work, community service, anti-theft classes, weekly drug testing, and a TAP evaluation that could lead to intensive outpatient or even inpatient treatment. The real turning point wasn't just the theft, it was the dishonesty around his drug use. That UA, positive for marijuana, meth, and opiates, forced the judge to question his credibility and tighten the reins. In the end, this case is about more than stolen metal. It's about work, responsibility, addiction, and whether someone is truly ready to rebuild their life. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. And tell me down below, do you think the judge struck the right balance between mercy and accountability here?